how that works within the legal system. So one, I was wondering, one, I was wondering if you could explain to me how the legal system works if there are laws that ostensibly should cover everyone, but that don't. And I guess more I'm sort of here thinking about job discrimination and hate crimes. So the argument would be, well, that creates a special protection. The law should already protect every individual. So, right? So why pass a law saying you can't hurt people based on their sexual orientation? And the other is, I was struck by Professor Rosky's comment about the tension over methods of, or strategies. Do you go after job discrimination law, or do you go after letting all people have access to the institution of marriage? And I was thinking about the nature of job discrimination law, that isn't it the case that most people that submit a case of discrimination don't even win, let alone the issues that you mentioned about, like, can you get a lawyer, do you have the time, do you have the finances? And so in terms of your strategy, Equality Utah strategy, are there ways that you could make reforms to the legal system or access to law that would empower people, that sets aside identity and then in some way avoids those accusations of special protection? And I'm not sure if I made sense, but let me know.
In response to the first question, one of the real difficulties of advocating for something like an employment discrimination law is that there is this common misperception that it's illegal to fire someone because they're gay already. Most people think that that's true across the United States, and I think it's only true in 20 states, right? Yeah, 20 states. So 30 states, it's perfectly legal to say, no gays apply, or I'm firing you because you're gay. If you go home. So that, and then you can. Then we have a clinic for low-income LGBT clients, and when people come with employment complaints, at least until April 4th, we tell them, I'm sorry, but at present, at least on the basis of your homosexuality, there's nothing that can be done. So we do encounter this, well, we don't need a law, why do we need a law? But then the explanation is because there's not a law, right? So that's part of it. There's, I think, a deeper question you're asking about when someone wants to call that right special or that protection special. And I think the first thing you do is sit down with the law, because what the law, our laws do not say you can't fire someone because they're African American. It says you can't fire someone because of their race. And it's very clear that it protects white people as well as people of color. And same as, you can't fire someone because they're a man or a woman. And I think when you explain that to someone, then it becomes very difficult to understand what's special about this right, what group is being specially protected. So I think that's usually the way we sort of address those questions. The tension over strategies is a perennial one in every civil rights movement and in every civil rights moment. And it is true that there are a lot of, that an employment law, as I indicated, is not, it doesn't make discrimination go away. It's one tool among many. And when you pick it up, you have to think about what you're trying to achieve with it. And in this case, some of the things we're trying to achieve are the embodiment of a protective principle in Utah law where none exists, for the cultural and social effect that that would have. The other one is to build a movement and to have conversations. And the reality in Utah is that 70% of Utahns are opposed to allowing gay couples to marry and even to enter into civil unions. But you can almost flip that around on its head. There's almost 70% support for an employment discrimination law, and there are cities and counties across Utah that want to pass such laws. And so this gives us an opportunity to have a conversation that we wouldn't otherwise have which I think is a very important organizing tool. And so I think those are the two things that we have in mind in making that choice. In fact, the barrier that we come up against when working for an employment discrimination law is they say that's just going to lead to a slippery slope down to marriage. So you can see how marriage is not a conversation starter in this state, it's a conversation ender. So I think that's the kind of things we have in mind.
Can I just add to that just a teeny little bit that even though I'm a lawyer, I actually think that we should not ever forget that, at least to my mind, the purpose of passing laws and challenging discriminatory laws and all that is not actually to change the law, just building what Cliff said. It's to achieve social equality. And the law is just a very powerful arena of discourse. It has a lot of effect in our, especially in our society, on the way people think about things, and that the purpose of enacting these laws is it codifies a kind of social respect that hopefully will spill over into people's attitudes about how gay people and others should be treated. But I think it's so interesting that the pattern in this country is the same everywhere in every state, is that people start out by being willing to give some respect, some protections to individual lesbian and gay people, but any type of law that recognizes or respects the relationship is a lot more of an uphill battle, and people are much more reluctant to do that. So they're kind of willing to take that step. Okay, fine, we will acknowledge that you are a human being who's entitled to the most basic equal rights. You should have a roof over your head, you shouldn't be fired because of you're gay, but we're not going to respect your relationship in any way. But, achieving the former does eventually lay a foundation for the latter. Yeah.
Okay, I saw another hand just there.
So I have questions about measurement, strangely, as an English professor. So Beth, when you began your talk, which is so completely interesting, you talk about the lesbian community throughout, so you obviously make that singular for a reason. And so I'm wondering, as a historian, how many documents do you need to have so that you can sort of say, here's how the lesbian community was thinking about this? Because talk about the non-event of the people not writing letters or not leaving documentation of what they're saying. How do we know that there weren't lots of voices in even the lesbian community that might have disagreed with that? But even if you have, a number of documents, at what point do you know that you've rounded up enough bodies sort of inside of that pen to sort of say, here's how the lesbian community was thinking about it, when it's the non-voices that might have just not been represented and saying other things like, I wish these other lesbians would stop writing those letters. How do we know what the other lesbians are saying? So there's one question about measurement. For Cliff, I'm wondering whether it came up. I could not be at the town hall meeting, as you know, because we were all busy planning this conference at a meeting that night. But I'm wondering to what extent, how much hate speech is good for us. When and how much, right? So I'm kind of going with arguments like Michael Cobb's and God Hates Fags or whatever, that hate speech is good for us, which I actually do believe at this particular point in time. When Chris Butters speaks, that is good for us. When he comes up with statements of such magnitude and insanity, this helps us. But obviously it's some sort of sliding scale of measurement, right? Because we've passed historically from a time when there was so much hate speech that it wasn't good for us. That's actually what has constituted a lot of our damage. And now we're in a kind of new period where sometimes hate speech is very good for us, but it's very hard in a kind of pragmatic, principled way to figure out where to set that bar. How much hate speech are we comfortable with? And what is the good that it's doing? So that seems like a weird kind of measurement issue at its core. And then for Shannon, the question of the hate crimes business that you mentioned, I just wonder how it can be quantified that there is this sort of greater negative impact. On the face of it, it sounds right to me in some ways, but if I'm raped 1 week by somebody and I don't know their precise motivation, I don't know if I'm going to be raped 3 weeks later by somebody who's raping me because I'm a lesbian, and then I could go before the court and say, actually, when it happened because I was a lesbian, that was a lot more negative than the rape 3 weeks before. I'm not I'm trying to be extreme to sort of get the point across. So I don't know how one can measure those things, given that they're generally not repeatable incidents, one hopes not, in somebody's life. So you can't get the same person saying this was more negative than another. So inside that experiment, how is negative impact measured to be greater? So measurement questions for the panel.
All right, maybe we'll take those in the order they were asked, and thank you for the very provocative questions.
I'd just like to say that I think Chris Butters is actually getting less useful for us now that he's set his sights on the 12th grade. And eliminating the 12th grade and making the 11th grade optional, I think we need more hate speech from someone else, because I think we've all now agreed in the entire state that he's insane. And apparently doesn't care about the economy, because we should definitely dump all of those kids. Yes, it is, exactly. It's a very crucial aspect. In terms of the, sort of what is representative data and how many times do you need to see something, and I mean, the writing about this, the research on this that I'm doing is very preliminary, and unfortunately there is no actual answer to that as a historian, because we're in the freaking humanities, okay? So we don't measure stuff. We feel about stuff. Yeah.
All right.
I admit it. Do you want to take this outside, Diamond? What I would say is I saw a debate, and that debate shocked me in part because of the viciousness of the state, right? So what was really striking to me and what made me want to focus the chapter that I had sort of vaguely dedicated towards parenting, right, because my project is significantly larger than that and is ranging all over the place. I'm talking about AIDS, I'm talking about, death and family decisions around dying and, all that kind of stuff. PFLAG, I mean, I'm all over the place. What was the really striking the manness of this, right? That there's no way that the family court cannot be seen as acting as the man in the 1970s and actually into the 1980s in representing patriarchal values in family structure. And that at the same time that you see on the same page of the same little lesbian journal coming out of Minnesota that's printed on, mimeograph machine, that you have literally the same page has the lesbian mothers losing custody of children and blah, 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 please send money, things are desperate, and why do we have to tolerate these boy children, or why do we have to have daycare, or, all of this stuff. And it just was so striking to me that these things could exist in the same space. And that the debates continued for so long and were so vituperative, right, so mean about these issues. Absolutely, there is a debate in the community. I need to tease out, for example, the difference between lesbians, lesbian feminists, and lesbian separatists. And obviously, everybody's moving back and forth in these categories. But it does feel that the very presence of this debate, particularly with the state evoked at the same time, all the time, and behaving very badly, that this is a really problematic issue within the community. And there are different voices, right? So there aren't plenty, but there are definitely very strong defenders of the rights of lesbian mothers to have access to the community. But to me, in some ways, the very existence of that debate implies that there is a broader position that motherhood and lesbianism are not actually easily combined. And there's a certain amount of truth to that, which is to say that it's pretty clear that motherhood and lesbianism are not easily combined. There's no daycare, boy children aren't welcome, and so these issues for me became very interesting in that way. But I saw it over and over and over again, which is a very historian sort of way of saying I think it is true. But what I saw over and over and over again is the debate. And that I saw that debate being effectively challenged by the early 1980s, in part simply by the emergence of the lesbian baby boom itself. So as women start to have children in lesbian relationships rather than from previous heterosexual relationships, that started to mediate. But it also was, in many ways, it felt like an organized defense based on the right to reproductive freedom. The reproductive freedom needs to mean more than access of straight women to birth control and abortion. It needs to mean that all women get to make choices about their reproduction and that nobody gets to police that, not the lesbian community, not the state, not broader feminist concerns. And so that would be my answer to the measurement question, which is, I'm a historian, what do you want?
So thanks for this provocative question. So how much hate speech is good for us? Well, like so many things, hate speech is good for us and bad for us, right? And so the question is, how much hate speech can you take, right? And that's actually, I think, what we've gone through. That is, when Senator Butters made this statement, the reaction was magnanimous and incredible, in that we did this event, the whole community got together and did this event, Butters Palooza. And it was a celebration on the Capitol steps of his statement for clarifying the reasons for the opposition to the Common Ground proposals and such. And you can do that the first time. Maybe you can do it the second time. But if there's that kind of speech all around you, at some point your desire to have a celebration ends. And it's very hard to say in the abstract when that happens, but you don't need to say it in the abstract. It happens here. And I do think that that's something that Equality Utah, like every queer organization, faces all the time. Hate speech can always be good for you, but it's always bad for you too. I also want to kind of just reframe the question a little bit to say, what is hate speech? Because what is recognized as hate speech is a very contested question. And the work that we do is designed to frame the conversation so that when Chris Butters speaks that statement, it is hate speech. And that is a very open question. The full statement, I wish I had it with me, was actually speaking to this point. He's being interviewed, and he said they're probably the biggest threat to America going down. And then he said something about an analogy to fundamentalist Muslim. He said right on par with fundamentalist Muslims. And he said, I think homosexuality is an abomination. Around here, when you say that, people go nuts. And so the fact that he has to say around here, when you say that people go nuts, that's an achievement, and that doesn't have to be true, and it wasn't always true. So working for that achievement, I think, is a critical thing.
Then you asked that hard question about hate crimes and how we know that someone is more damaged if they're targeted because of a personal characteristic than not. And I don't know, I was going to see if Professor Rosario can help me on this, but I'll give my little attempt at an answer, but based on the conversation we were having last night, I'm hoping you might have some thoughts on it. But I'm not sure that there are any objective, quantitative ways to measure that, but I think just as a matter of human psychology, that anyone probably could imagine that, if somebody like accidentally hits you or something, like that could be hurt and it could be upsetting, but it's even more upsetting if someone does it on purpose. And then if someone does it not only on purpose, but, hits you and says, and calls you a derogatory name relating to your race or gender or sexual orientation, I think for most people would have an intuitive sense that that is more upsetting and damaging. So I don't even know if you would need to do like some kind of, controlled experiment to have the same person experience that event where it's accidental or on purpose because of who you are, and see how upset they were on each occasion. So much as just as a general matter, it's likely that people would be more upset and more damaged by that. I think but this is where you may or may not be able to help me, I don't know. I actually think there are some agreed upon ways to measure the impact of stressful events, like looking at negative outcomes like depression and the kinds of stuff that was talked about, that were discussed on the panels yesterday, substance abuse, suicide attempts, that kind of thing. But it's interesting to use the example of rape, because some people argue that rape by definition is like a hate crime because it has such a gendered aspect to it. Although that has come up in really interesting and upsetting ways in like some asylum cases we've worked on where gay men have been raped by police officers and private actors, and we've had to actually, that tends to be discounted by courts as like somehow not counting. And so we had to present all this expert evidence in some of these cases showing that actually, yes, men are just as damaged and traumatized by rape, and that rape can be used as a tool to demean a person's sexual identity as well as just based on gender. It's really interesting. And the other thing that I was thinking about is that, you know, the campaign of lynching and other types of violence around the turn of the century, and how, you know, that, I mean, there I think it's easier to grasp, wow, yes, that really, there is a kind of damage there that goes beyond just the death of those, terrible death of those individual people that you're sending. You really are terrorizing an entire community of people. But I don't know if there is any way to objectively measure.
I was going to say, you know, we hypothesize, and for us, the key is the outcome. So if we see increases in indicators of distress or pathology, we know that that's something important. The other thing, that's with human beings, since obviously we're not going to submit individuals to stressors in the laboratory. But we also do it with animals. I mean, we certainly are able to see what happens in animal colonies. We've done this with rhesus monkeys, and we could also do it in the lab. So those two pieces of information are put together, and we're able consequently to speak about the potential damage that can be done as a result of exposure to a variety of different kinds of situations.
There's a question in the back. Dallas? I'd like to just integrate a little bit more, and I'll come right back. Okay. Yeah.
Hello. I just want to thank you for coming out, because I believe that exposure and education to these ideas are just so essential to opening minds, and thank you so much for coming out. But my question was about the LDS Church's participation and support of Proposition 8, and I was curious as to how that is in regards to, you know, separation of church and state and their tax-exempt status and their own freedom of speech and the right to organize, and kind of your thoughts about, you know, their support of that.
You know what I'd like to do is actually take a few questions, because I saw a number of hands, maybe get them out in the atmosphere and we can respond to them in terms of someone back here.
I had a follow-up question, but Catherine said why I was holding the mic.
This question is for both Professor Rosky and Mr. Minter. I was wondering if you could speak to the applicability of an ordinance such as the Salt Lake City Ordinance to private actors versus just a government actor.
Was a follow-up to Catherine's, so actually you should go ahead and take those are the two that I see. Okay. And that was is back to Beth about trying to get, you know, as a fellow historian who really doesn't try to quantitatively measure, you know, trying to get a sense of how you can generalize about the politics of motherhood within lesbian communities in the 70s. One of the things that struck me that is like highly relevant to sort of thinking about the representative issue is that there was a huge debate between white lesbians and white lesbian separatists and lesbians of color precisely over that issue, about all relationships with men and about children, in which white lesbian separatists were critiqued, like the Combahee River Statement and lots of other, that there was, I mean, that was a point of pretty stark contention. And that, you know, so that besides the debates, say, among white feminists or white lesbian feminists, white lesbian separatists over, you know, ambivalence about motherhood, placed in a certain kind of a larger context of a history of pronatalism for privileged white women, you know, so there's like a reaction to pronatalism. But then there's this other context of where there's certainly, it's not pronatalism when you're talking about women of color or poor women. It's not the historical context. And so the, you know, relationship and the set of it around that are so different. So I think, though measurement is certainly not something that a cultural historian is going to try to do, trying to produce a kind of representativeness, it's a function of context, and that it's like there's a series of overlapping contexts for thinking about that, and I think the racial conflict over that is sort of one kind of crucially, it alters the landscape in a way. So that was the comment back.
Okay. So we've had a comment on really, I think, diving deeper into this question of context and the multiple debates within an internal private community. A question going to private actors and how far it is or effective can city and local ordinances be in constitutional and other law, appreciating that often what we're concerned about is the state action. So what is it about private action that we can capture, because arguably a great deal of violence emanates from sources that are private as well as discrimination. And then finally, an invitation to comment on, I guess, more broadly and generally, Proposition 8 as it was pursued in the political process, and questions over balancing arguably religious liberty or opinion expression and speech against tax-exempt status and equality arguments from the LGBT community. So I may not have done justice to those comments and questions, but I invite you to respond.
Sure. I guess in response to Lisa and Catherine's comment, I absolutely agree that it is an issue of context, and these debates are going on. There are overlapping debates about overlapping issues. And one of the things I was struck by in the kinds of data that I was looking at actually was the difficulty in assessing a variety of identities for the speakers, because I'm looking at newsletters, and in my old research I was looking at prison records, and they told you what people's race or ethnicity or immigration status was. It was very clear. And so it's been a little disorienting to be working in terms of this. The nice part is the ways in which people, through newsletters and other kinds of media like that, are speaking for themselves, which was something I didn't have in my previous project. So prostitutes not really mouthing off as much as we would like to the social workers, who then are not necessarily writing down all of this identity-based stuff. What I have noticed is that and so it's hard to assess who is speaking and in what way. And, you know, the fallback position, which is totally untenable, is to say that these people are white, right? And they, although whites do tend to speak as if they are the universal category, and it, you know, it's only when people identify as not in that way that you see that sort of cropping up. It is true that the defenders of lesbian mothers consistently defend motherhood in a way that is much more, pays far more attention to both race and class than others. And class is a particularly big category for them, because poverty is such a huge issue for lesbian mothers and mothers in general, regardless of race, or certainly single mothers in general, or and mothers with women partners. And I need to do more work on this, obviously. The other thing that I think is interesting is the way that the state is intervening in these issues of race and class in relation to lesbian motherhood, and then the way that the community seems to respond, and the way that certain actors in the community respond to that. And that's particularly obvious in relation to this aspect of politics and whether or not the home or the space that contains children can be political. So one of the ways that men try to discredit lesbian mothers who are their ex-partners and ex-wives is to say that the home has become political, and one of the clear identifiers for politics is simply that it contains people of different races. So you have fathers making the argument that they should have custody, not just because the mother is a lesbian, but because the mother's partner, who is white, has a black son. Or the family, because it's poor, will be in an interracial neighborhood. And as a result, you know, we in the 1970s see this as an inappropriate place to raise children, and therefore fathers' rights should be held as over and above those of other people. But the defenders of lesbian mothers are much more explicit about that, about both class and race as issues, and about the rights of women much more broadly to control their reproductive freedom, meaning both to have children and to not have children, and to raise them in different contexts. And I think in part it's because people really are are comparing apples and oranges. So the folks who are opposed, particularly to boy children, are really talking about the establishment of separatist communities that are supposed to function in certain ways. and they're not really thinking, at least in the data that I was looking at, the newsletters and stuff, they're not really thinking about, you know, what that purity means in terms of race or social class. And they obviously would never say, we don't want poor women, we don't want black women, but that seems to be, they seem to take on a whiteness, a normative whiteness, that the lesbian mother folks and the lesbian mother defender folks are rejecting. So that's what I'd say.
Well, can I just tag on to that? Just one. It's a bit of a tangent, but I just keep thinking about it. Yeah, I guess I mentioned that where I work, National Center for Lesbian Rights, it started in the late 70s. You know, in this context, so it's controversial on both sides, like both within the community, because having children and defending women, lesbians who had children was not necessarily popular with everyone, as you've described. But it was also, there were other gay rights legal organizations around at the time, but they did not see issues around parenting and custody as civil rights issues. They were seeing like personal problems that women had, and who cares? Like, we're focused on the important business of challenging sodomy statutes and stuff like that. So it was like I've just heard the woman who founded NCLR, who's now a judge in San Francisco, Donna Hitchens, talk about that many times, about just the challenges of getting the larger, to the extent there even was a sense of and lesbian and gay, much less LGBT community at that time, getting support from particularly gay men, honestly. But of course now that's all shifted, and so many gay men are having children too, and now some gay men are complaining that people don't think only lesbians have kids. So it's just it's interesting, all the twists and turns that's all taken.
So on the point of private actors and state and city ordinances, as well as Prop 8 and the status of the church and balancing liberty and equality.
Sure. So the question of the extent of the church's involvement in the both financially and otherwise is a contested one. California is currently investigating the level of financial contributions from the church. The initial report that the church made was of a very small amount of money. I think it was a few $1,000s, but I could be wrong about that. And then when the investigation was launched, they were given an opportunity to submit a revised report based on a sort of clarification of the rules, and it was more on the order of, I think, $100,000, although I can't remember. And now there's a movie, a documentary that makes a lot of bold claims about the church's involvement, and documents have been produced and sent to California and to the trial, and the suggestion of the documents is that the church may have taken steps to solicit individual donations that could then be submitted and that would not compromise the church's nonprofit status. Whether or not that is inappropriate is actually not clear at all. And what the rule is simply not clear at all. That is, you can't contribute a substantial amount, but what's a substantial amount? The church has more than several $1 billion in assets, so is $20 million substantial? No one knows the answer to that question. And so that's going to continue both as a matter of California administrative law, trying to figure out what was done, and also I think tangentially has been raised in the Prop 8 trial, not that it would be resolved there, but the question of the church's involvement. And then, so then the question of, excellent question about private actors and the status of private actors under the discrimination ordinances. And just as a backdrop to that question, when the church made these statements that said, we're opposed to marriage, but not, gay couples marrying, but we're not opposed to these basic rights, they had a caveat. It said, so long as these rights do not infringe on the traditional definition of the family and upon the rights of churches and religious adherents to practice their faith. And so that question actually comes into the status of what is the effect on individuals of these anti-discrimination statutes. So one thing is, employment laws don't apply to individuals, they apply to employers, corporations, partnerships. And they include certain exemptions. So if an employer has fewer than 15 employees, they're exempted from the statute or the law. And the housing there are similar exemptions in housing ordinances. If you have fewer than 4 units, or you live with the people who you rent to, you can be exempted. And in Utah, we actually have quite broad exemptions for churches, religious organizations, religious corporations. There has been a move recently to expand the exemptions to include all religious adherents based on the church's statement. So that, and it's not clear what that would look like, but it seems like the exception that would swallow the rule. That is, you could fire someone or evict someone because they're gay, and then you get sued for that, and you say, I did it for religious reasons. And then you have this sticky situation in which a judge is going to determine whether or not you're a person of legitimate faith and making a legitimate claim or not. And for obvious reasons, government very reluctant to do that, and might actually be a violation of the First Amendment to make that judgment. So it seems like an effort to, particularly if the laws don't apply to individuals but to the corporation, it's not clear why we need an exemption for religious individuals.
Cliff, can I ask you a question?
Yeah.
Well, it seems to me that there might be an interesting parallel between the LDS Church's stance through the early 70s, right, to not give African Americans the priesthood.
Yeah, I was thinking about the Bob Jones University
gap,
case, too.
Like, the Civil Rights Act 1964, allowing blacks to hold the priesthood mid-70s, is there any case law that tried to adjudicate that kind of, do you know what I mean? Like, so it's an interesting comparison to, issues of equity and race law and a religious position. So if some landlord or employer in the early 1970s said, I discriminated on the basis of him because he can't, hold the priesthood because he's black, I guess it's maybe too specific a case, but it seems like it's a long period of time for there not to have been some kind of
and there's a
issue.
famous Supreme
Like 10
Court
years,
case, Bob Jones University prohibited interracial dating and lost their tax-exempt status under federal law for doing so. And I am, by no means am I an expert. In fact, know very little about tax law. At all.
There are no tax lawyers in the room today, probably, that recycled around. So
probably not going to be able to give a satisfactory response beyond what I've got there. Sorry.
No, I know, huh? That's very flattering to me. I'm actually really glad you asked that, because I was thinking that when the topic came up. I think there's an enormous amount of confusion, and that a lot of people have this idea that separation of church and state means that people who are religious or religious organizations or organized religions like the LDS Church or the Catholic Church or any type of religious faith are not allowed to voice opinions that are based on their religious beliefs, and that there's something improper about that. And that is absolutely not true. Of course, people have every right, and it is a highly constitutionally protected right, to participate in the political process, to advocate positions based on their religious values and beliefs and faith. And it's just completely the opposite of being prohibited. It's actually very highly protected in our constitutional system. But where things do get a little bit confusing is, and Cliff was alluding to this, there are, however, limits on what any nonprofit, including religious organizations, how much money they can contribute to actual political campaigns. And the current law lets you, it's a vague standard, as Cliff said, you can contribute more than a substantial amount. That's worked pretty well up to now. It really hasn't been a big issue. Like, I work for a nonprofit. We contribute a certain amount of money to various political issues, but we just have to be careful that it doesn't go beyond. Actually, there is, not to get into the deadly boring details, but you can opt to sign yourself up for this one sort of regime of enforcing this, where you can spend up to 25% of your overall budget without getting into trouble. But what has now been raised for the first time because of what happened in the Prop 8 campaign, which just as a factual historical matter was unprecedented. We have never before had two organized religions, this case Catholic Church and the LDS Church, be involved at such a high level of involvement. I mean, we now know from evidence presented in the Perry trial, there was a very high degree of coordination going on between the leadership of the Catholic Church and the LDS Church were cooperating together, which has never happened before to anyone's knowledge. And they were coordinating very closely with the actual official Prop 8 campaign and raised just enormous sums of money, and also contributed thousands of volunteers. Basically, the field effort for Yes on 8 was simply the LDS and Catholic parishes and whatever the right wards, getting their members out to go door to door, and that's just nothing on that scale has ever happened before. So for the first time, there are now proposals to change the existing legal framework and put more restrictions on how much nonprofits can contribute because of the very thing that you mentioned. Because even though there's this limit, you can only spend a certain percentage of your overall budget on a political campaign. If you have an organization that has billions and billions of dollars, what for them is still a limited percentage could actually dictate the outcome of the initiative, because it is, in absolute terms, so much money. So we're now, for the first time, starting to see people proposing, hey, maybe we actually need to change the way this law works.
But of course, the Supreme Court's recent decision on the right of corporations to speak in political campaigns further muddies this entire field, because that principle that organizations, corporations can speak, arguably could be extended to nonprofits, right? That one could find constitutional questions about the limitations in nonprofit law that keep nonprofits from being First Amendment actors.
Yeah, good point.
Okay, there's another question. David?
I know we're running short on time, or I think we are, but I just want to ask a somewhat naive question that might link us to some of the panels yesterday. Shannon, in your talk, you talked about Ilan's testimony in the Prop 8 challenge, and it sounded like you spoke with some admiration for the testimony that he gave. And I know when I read the blogs, people referred to him. This is Ilan Meyer, who's a scientist. Referred to him as, like a rock star, and people were really excited about his testimony. And so my question is about the role of science in sort of the judicial process and the legal process. And it's naive because I'm a scientist, but I understand very little about that process. In your talk, Beth, you talked about some of the things that the court said sort of in the 70s and 80s about lesbian families and about their suitability. And unfortunately, we see those things repeated in decisions, within the last 5 years, where they talk about, the essential nature of having one man and one woman raise a child. And those are things that most scientists today who work in this area understand are just flatly absurd. And so I guess my question is, how can courts do that and say those things when it's pretty much agreed that it's just not true? And what influences whether a court sort of is influenced by science or not influenced by science, or cares? And are they allowed to just dismiss science? Is that part of the process?
I actually had a similar question for Shannon as well, which is, it seemed to me that the reliance of it's not the court at this point, but the reliance of the challenge on science was interesting in relation to the way that worked out in Brown as well. That it's really sociological data in Brown that seemingly sways the court around the issue of whether or not harm is actually being done in the segregation of children. And the decision is very clear and very clearly based on scientific. We hold that in the field of publication, education, separate but equal, will not stand. Separate educational facilities are inherently unequal because they create a sense of inferiority in the child that is being segregated. And so I kind of wondered whether people were talking about that and thinking about how one plays out science in these kinds of cases, and whether you guys were deliberately using scientific research.
Sit on those air quotes.
In that way.
Yeah. Oh, gosh, yeah, I love this question. Well, yeah, the presentation of evidence and scientific evidence in these cases is hugely significant, and it has played a big role in other civil rights cases as well, most prominently Brown versus Board of Education, where the court relied heavily on sociological literature showing that African-American children were actually psychologically injured by segregation, and that was a really important part of that decision.
As well as totally flat out educationally, right? Injured by it as well. But
Right. I mean, the very premise of that case was very similar in some respects to the question posed by states that do give gay couples all the same rights of marriage but not the status of marriage, because the premise that the court accepted in Brown, questionable whether it was actually true, but I think they did it to make the point that even if the separate educational facilities were actually materially equal, there would still be a cognizable constitutional injury caused by the psychological stigma of the government saying we're going to put you in a separate schools. I mean, we've talked before about how difficult it is throughout the conference, how difficult it is for people in a majority or dominant group to really appreciate or understand the impact of discrimination because it doesn't affect them, and it just seems very sort of abstract at best, and people have a natural human tendency to discount harms that they are not themselves experiencing, in fact, even have difficulty even recognizing that they are real or that they really exist or have an impact on people. So that was the amazing thing, and it was, Dr. Meyer was a rock star. It was really, really powerful, and I mean, the perfect example is that stuff about the filling out the forms that I tried to share with you all. Because honestly, you know, you have testimony about that from gay couples, and you can tell that they're bringing a lot of emotion to this issue. Like, you know, when we have to fill out forms, but you know, it could be easily dismissed. Like, well, big deal, you know, you're really like filling out a form is really you're going to ask me as the court to hold that constitutes a constitutional injury, so I'm going to strike down this law that's been enacted by majority of the people of California. But what Dr. Meyer's testimony, he sort of filled in the blanks or just very methodically explained to the court why that experience actually invokes this entire structure of stigma and rejection, so that it really is, from a scientific social psychology point of view, it really does inflict a very serious injury. And especially when you think about the repetitive nature of it, happens over and over in every turn. And then he just laid out this whole framework that I try to, in very abbreviated form, share with you guys, and it was extremely powerful. And your question, though, about whether courts have to consider this kind of evidence, I'm not...
What are the circumstances when we see them just flatly ignoring, like, very well-accepted science?
Right. Well, that gets into something that Professor George had asked me to address, but I just couldn't work it in, so now I'll just do it really quick. But it depends to a certain extent on what standard they're applying. So if you're bringing an equal protection challenge, it's either going to be this very low level of review called rational basis review, but it doesn't matter what it's called, it's just a very low level review, or the court has recognized that certain classifications are so likely to be based on prejudice and bias that the court views them with great suspicion. That's where you get the suspect classifications, and that the court is going to look at any law that classifies based on race, religion, gender, national origin really closely. And if the state is going to defend a law like that, it has to present evidence to prove to the court that there is some compelling, really good reason that you need to classify people on that basis. So a big question in all these marriage challenges is what level of scrutiny should apply under equal protection to laws that classify based on sexual orientation. The Supreme Court's never decided that. It's a totally open question under federal law. There's only one state court that's ever said that sexual orientation is a suspect classification. That's the California Supreme Court. So if the courts are only applying that low level of constitutional review, facts don't matter. Part of what is built into that standard is that as long as there could be any possible, reasonably conceivable reason for the state classifying the way it does, even if it's hypothetical, even if it wasn't the actual reason, even if it's a huge stretch, that's good enough under that standard. So that's why you get courts like, even very respected courts like the highest state court in New York, the New York Court of Appeals, saying, yeah, well, we know there's all this evidence that gay people are just as good of parents as straight people, but the state can still exclude gay people from marriage because theoretically, hypothetically, the state could decide, well, gay people can't accidentally procreate. Only straight people can accidentally procreate. So maybe straight people have a greater need for marriage than gay people.
I know several gay people who have accidentally procreated.
I know lots of them. I know.
I think that's a very helpful explanation of these constitutional law cases and the way your question comes up in those cases. But I think there's also a broader point to be made about the use of science or, frankly, history in law. There's an expression, lawyer's history is a sort of dangerous thing. And what you know when you hear someone talk about lawyer's history is that it's not good, right? That it's being used strategically, that this piece of history and that piece to make an argument and support it, and the things that don't support it are left out. Science certainly used the same way in law, and that the nature of an adversary system is that you get these battles of the expert, and so that even though 99% of scientists agree on one thing, then there's the one scientist that they call to the trial and they get equal time, and it's like, well, we'll let the jury decide. It's this kind of black box in the law. And interestingly, the issue continues to come up in the cases involving lesbian mothers, particularly and sons, and this will link to our panels from yesterday. That is, even in the 90s, in cases, it's very specific. It has to be lesbian mothers litigating against straight fathers over the custody or visitation of a son. You see psychiatrists come in and talk about gender identity disorder of childhood. And they say, this boy is going to be confused about what it is to be male. And to Lisa's point yesterday, gender and sexuality are just completely intertwined and conflated in these statements, right? And so this science, and it's very much this old idea of a domineering mother and an absent father produces an effeminate boy, which is not just not true, but debunked science, right? And supposedly taken out of the DSM, and yet is sort of lives on in this little space and is exploited by the litigators on behalf of the heterosexual fathers in those cases. So, and that's in the 90s in states like Indiana. So that's not long ago or far away.
I saw one other question here.
Okay. I won't take long. Have any of you read the Dallin Oaks? I'm getting back to the Mormons and the Constitution. Have any of you read Dallin Oaks' recent speech to BYU Idaho?
Is this the one where there was an analogy made between?
Well, he basically uses the First Amendment to justify calling out the members to go back into the public squares and putting religion back in government. And then the other thing that I thought was interesting, in Michael Otterson's radio show after the ordinance speech, Michael Otterson is the church spokesperson. He said there are times when constitutional rights butt up against each other, and he didn't say in the case of marriage, but he kind of alluded that the First Amendment freedom to practice religion may trump the Equal Protection Clause. And so I'm just saying to the con law professors, I'd love to see some stuff, op-eds and other things go out into the newspaper commenting on Oakes' recent speech, as well as sort of this constitutional position the church seems to be taking.
Yeah, and I'm not sure if we're talking about the same speech, but I read something by Elder Oakes a while ago in which there was a lot of argument that the reaction of the queer community to the passage of Prop 8 and the protests and the threats of boycotts were violations of the church's First Amendment rights and the religious adherents' First Amendment rights, and there was an analogy made to the Black Civil Rights Movement, the denial of the right to vote. And there was, I think, Elder Oakes is a sort of deeply knowledgeable legal scholar, and I was surprised by the sort of failure to mention that the First Amendment says that Congress shall not, deny the freedom of speech, and that there was the government never threatened to boycott the church. The First Amendment simply does not regulate boycotts; it permits boycotts, and so there's a lot of, I think it's fair to say, kind of, defensive rhetoric, frankly, on both sides. But invoking the First Amendment for these defensive purposes that is somewhat confused, right? That if the government is not inhibiting someone's speech, then there's not a First Amendment issue there. I think the genuine issue that comes up that I missed the name, but Michael was referring to is most clearly present in public accommodations laws. So these are laws that say that things like restaurants and hotels can't discriminate based on certain characteristics. And there, when you combine a same-sex, a law that allows gay couples to marry with the public accommodations law, you get into these rare but difficult and delicate conflicts between people's rights. I don't know if you want to call them constitutional rights, but certainly rights. So there's a case in Canada where the Knights of Columbus had a hall, and a woman called up to rent the hall for her wedding reception, and there was some miscommunication about whether it was going to be a same-sex, and then when they found out it was same-sex, they said, we're taking the hall back, you can't, we won't rent it to you, and it was too late, the invitations had been written, and Canadians manage these conflicts much better. The Canadian court said, well, we're not going to force you to apologize, but certainly what you did was wrong, and really kind of said, you should pay for the invitations and the rental of the other hall because you've inconvenienced these people, and so whether that's deeply satisfying, perhaps not, right? But these conflicts do come up, and in general, I think that they're rare and easily managed through common sense and mutual respect more than anything else. But they're not conflicts between the First Amendment and the Equal Protection Clause because, like the First Amendment, the Equal Protection Clause applies to government, not private individuals.
Okay. Well, please join me in thanking a really spectacular panel. I think we're all better for it, and it's learned a tremendous amount. Okay, we will now have a short break before moving on to our fourth and final panel on public shaming. So we'll reconvene here at 11 o'clock. Thank you again.